Hi, everyone. Thank you for joining us today for Constangy's webinar, When Termination Becomes Litigation Risk, Using Severance Strategically. A couple of housekeeping items before we get started. If you have any questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Their contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We will be sharing the codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters, Gary Wheeler and Colin Thakkar.
Thank you. Good afternoon, everyone, or good morning, depending on your time zone. I appreciate you taking the time to join us. Today, we're going to be talking about severance, but not from a drafting perspective alone. The focus is going to be on when termination decisions start to carry litigation risk and how severance can be used strategically to manage that risk. I'll be covering the front end analysis, how to think about these decisions. Then Colin will walk through the execution and mechanics, where a lot of employers unintentionally create exposure. Okay, well, first let's talk about the litigation environment and the way it's shifted in a number of ways that matter for employers. Summary judgment is less predictable than it used to be, in my opinion, and that's not only because of classic factual disputes that come up during litigation, but there's also been increasing discussion about whether courts should rely less rigidly on burden-shifting frameworks like the McDonnell-Douglas framework and focus more on the totality of evidence. The McDonnell-Douglas framework is a very popular framework that's been used for years, and it's always been a tool, but courts, especially the Supreme Court and Justice Thomas in particular, have really emphasized that it is only a tool. It is not a checklist, a test in and of itself, and essentially kind of encouraging courts to look at the totality of circumstances. Okay. My partner, Tammy Woolley, wrote an excellent late 2025 article on this trend called The Erosion of the McDonnell-Douglas, What Employers Should Know. So if you're involved in or anticipating litigation, you may want to review that article. At the same time, state law is becoming more and more complex, particularly around separation agreements. This has been a trend, I'd say, for the last 15 years. Prior to that, the area of employment law was dominated by federal law. It's less so that the case now. And then finally, the plaintiff's bar is becoming more sophisticated in how it evaluates and pursues claims. The result is this: decisions that are legally defensible are still being challenged and costing employers real money to defend. Okay, before we get too far into strategy, I want to be clear about today's key term, severance agreement. The severance agreement is a legally binding contract that governs the terms of an employee's departure. The employer provides consideration, usually compensation or benefits, in exchange for the employee providing a release of claims. One key point: severance is not legally required in most situations. This is not something employers have to offer. It's something they choose to offer as part of a management decision. Okay. So this leads to the core question behind every termination. Is this a situation where we defend a decision or one where we consider resolving the risk early? And those are not the same question as did we do anything wrong? That's a popular question that employers reflexively ask themselves, but in my view, it's really not the appropriate question to ask when you're considering um, the severance agreement. Legal defensibility does not always equal economic efficiency. You can have a defensible decision and still face um, a claim that's expensive, time consuming, and unpredictable. So, a related concern that we sometimes hear is regarding unsigned severance offers. That is basically severance offers that have been given and declined or rejected by the employee. And the question is, can that be used against the employer in evidence in litigation to demonstrate the employee's belief that the employer knew that it was doing something wrong when it terminated the employee? In many situations, offers made to resolve or avoid disputes may receive evidentiary protection, but the analysis can depend on the jurisdiction, timing, and the purpose for which the evidence is offered. So, more practically, employers offer severance for many legitimate reasons: cost certainty, business efficiency, confidentiality, and risk management. It's not inherently an admission of wrongdoing. In my experience, while this issue should be considered, it is usually not a compelling reason to avoid an otherwise sensible severance offer. Okay, when used correctly, severance buys several things. It often buys a release of claims, and that is usually the most obvious benefit. But it's important to understand that releases, while broad, are not unlimited. Certain rights simply can't be waived by uh, privately waived in the same way. For example, unpaid wage claims under the Fair Labor Standards Act often require Department of Labor approval or court approval and to be fully resolved. Workers' compensation rights and unemployment rights are also typically governed by statute and administrative process rather than private waiver language. So a severance agreement can significantly reduce risk, but it does not eliminate every possible issue. It also buys certainty. It reduces disruption to management and it can protect reputation. It allows for a controlled, confidential resolution. So the important framing here is that severance is not about generosity, it's about allocating risk. Okay, there are certain indicators that should cause employers to at least consider severance. Protected activity is a big one. Complaints, internal reports, anything that can be framed as retaliation or the start of a potential retaliation claim. Employers should also consider leave history under the FMLA, ADA, or state law equivalents. Those issues tend to be to complicate cases. As we know, employers are more than just their HR departments. So sometimes HR departments will discover that frontline supervisors have used weak or inconsistent documentation, and sometimes just personality risk, employees who are more likely to pursue claims. You just have a intuitive sense that this person is unlikely to go away without bringing a claim. So the key is not whether the employer did something wrong, it's whether the situation is likely to be challenged. Sometimes employers assume a strong defense means low risk, and that's not necessarily the case. For example, here's one area where I've noticed this is particularly true. FMLA abuse cases. Employers often have powerful defenses if they act on an honest and well-supported belief that somebody claiming FMLA entitlement is actually abusing it. A classic example is somebody takes FMLA leave and then is spotted, helping their brother-in-law with a lawn care business and is working in a particular area where they feel like they can make more money in a short period of time, and is misusing a federal and employer benefit to do that. So, but the same issue that puts that employee willing to misuse leave might make them highly motivated to sue after termination. They just have a certain amount of moxie. So the employer may be right on the merits and still face litigation risk. On the other hand, there are situations where severance may not make sense. Some thoughts come to mind: a clear resignation, a clear policy violation with solid documentation, where there's likely to be low damages in the event that the claim is made. An employee only has been there for a short period of time. In those situations, the likelihood of a claim and the potential value of a claim may be low enough that severance isn't necessary. The important point is that severance is a tool, it's not the default. Okay. Even when employers ultimately win, litigation is expensive. You have the cost of responding to an EEOC charge. You have early mediation, discovery, summary judgment briefing, and potentially trial preparation. When you compare that to a modest severance payment, the economics can shift quickly. Again, this is about cost versus risk, not right versus wrong. It's also helpful to think about how plaintiffs' attorneys evaluate these situations. And I don't know this for certain, but I've always put myself in the position of my opponent when I'm representing an employer in some kind of disputed issue, and uh, try to play out how I would act if I were representing their client. And when they see a severance offer, I believe they typically the response from the plaintiff's attorney falls into one of three categories. When they're showed, the offer, whether it's in the context of a severance agreement or some other kind of resolution of a dispute. And generally speaking, the plaintiff's attorney is going to classify, hey, that's a good offer. That's or your call, entirely your call. I mean, technically all of these are the plaintiff's call or the employee's call. But if they say either good offer or your call, they're uh, not it's not as unfavorable as the last category. He says we can do better. In that case, the plaintiff's attorney is shifting from advisor to potential advocate, and they're basically encouraging their client to reject the offer because they think that they can do better by potentially litigating against the employer. So understanding that dynamic helps employers think not only about the timing and structure, but also the amount. In other words, the question is not simply what the employer wants to pay, it's what is the amount that has a realistic chance of resolving that risk. Okay, before offering severance, there should be a disciplined internal process around the underlying employment decision. Most often that's a termination decision. Okay, so obviously you need to document the decision clearly, make sure the reason is consistent, review comparators where relevant, audit any leave history, look for prior complaints or protected activity. Now, this matters for several reasons. The first is the severance offer may not be accepted, which means the employer may still need to defend the decision. Second, the employee's counsel, like we discussed, will often evaluate the circumstances of the decision when advising whether or not to accept the offer, reject it, or push for more. So it's not just about being right, it's about being able to explain the decision later in a consistent and credible way. Okay, this slide illustrates a critical distinction and one that creates a lot of risk. Final pay includes wages, overtime, PTO where required, and earned commissions or bonuses. Those are obligations. Severance is different. It's a new consideration something that's offered in exchange for release. Those two buckets need to remain separate, and I'm just going to briefly explain this from a helicopter view. Colin will be diving into this in more detail. Employers often run into trouble because severance is being discussed at the exact same time that final pay is being calculated and delivered. Okay. This is where I want to shift the focus. Many lawsuits don't arise from the termination decision itself. They arise from how the termination is executed. Even a well-reasoned, defensible decision can become much harder to defend if the execution is inconsistent, if it's rushed, or if it's unclear. So there are a number of reoccurring execution issues: timing pressure, short deadlines, weekend decisions, shifting expectations. Pay structure issues. You could have misaligned payroll cycles or unclear payment timing. Separation structures like resign or be terminated today can create coercion arguments. And one of the biggest issues, commingling wages that are owed with severance that is being negotiated. So you can also see communication missteps or breakdowns in the offboarding process. So these are operational issues, but they show up in litigation regularly. Okay, at this point, I will hand it off to Colin, who will walk through the execution and mechanics.
Okay, thank you, Gary. I appreciate it. And as Gary had mentioned before, there are two buckets really. When a company is considering entering into a severance agreement with an employee, they are thinking about how to address any lingering risks, any risks that have been created in the past. They should not be thinking, or they should be making sure to protect against creating new risks. And severance involves pay that is discretionary, basically pay that is not owed already to the employee, or that will not be owed to the employee as of the end of employment. On the other hand, the employer is going to be providing something to the employee that is not owed to the employee in exchange for the employee waiving certain rights, including the right to file a claim or to file a lawsuit. And final pay, on the other hand, is something that's owed as of the end of employment, basically the employee's final paycheck. And so those buckets should always be kept separate. There's often a tendency when at the end of somebody's employment, a company is also considering entering into a severance agreement with them. There can be a tendency to try and take any additional money or benefits or anything that could be provided to the employee and make that contingent on the employee signing away certain rights to file a claim or to do anything else. And that, as I said, final pay should be kept separate, and it must be done right. And so with this slide, I'm talking about the timing. Oftentimes, people think that the timing of a final paycheck, or really the timing of any paycheck, is set by the Fair Labor Standards Act. But when you actually look at that law, there are no specific requirements regarding when pay needs to be provided to the employee. Really, the only requirement is that pay must be provided promptly. And so what does provided promptly mean, especially in the context of a final paycheck? What it means is that the final paycheck must be provided um, by the next normal pay period. However, that doesn't mean that that in every state the final paycheck must be provided by the next pay period, because as Gary mentioned, uh, states have become much more detailed in their in legislation, introducing legislation related to employment law, and legislation specifically related to payment of compensation. And so when you look from state to state, um, you see in most situations there is a state law regarding the payment of wages, as well as the payment of final compensation. Um, Also, because nothing can be easy, um, each state has its own ideas about how an employee should be paid, and regarding the timing of payment. So in a number of situations, you see um, states taking the maximum, most difficult position for an employer, which is to require the employer to pay the employee their final wages on the final day of employment, which can be very difficult, because oftentimes uh, a a decision is made in the moment to terminate somebody's employment, and oftentimes a termination decision is made as a result of some action by the employee that makes immediate termination the only appropriate route. And so uh, you look at states like California, Colorado, and Massachusetts, you see that there is a requirement that in the instance in the situation of termination, involuntary termination, there's a requirement that they be provided their final pay on the last day of employment. There are other states um, that either don't have their own law regarding payment of or regarding the timing of final payment of wages, or that and that as a result, federal law applies, um, where the final wages must be paid as of the next payroll, or the next pay date, or there are states where it specifically states that the final paycheck must be provided by the next regularly occurring pay pay date. And there are other states that are somewhere in between. For example, Alaska states that the final paycheck must be provided within 3 days of the employee's final day of employment. And there are others. I'm forgetting, it may be Arizona, but there's another state that requires payment be made 8 days after the final day of employment. So it's just very important that all employers understand the state laws regarding the timing of final payment. Another thing to look out for is that states often differentiate between the situation of involuntary termination and the situation of resignation. So, for example, California doesn't just have one rule where an employee must be paid on the final day of employment, regardless of how the separation occurs. In actuality, it's payment must be made immediately if it's in the case of involuntary termination, but within 72 hours in the case of resignation. Um, in Colorado, it's either immediate for involuntary termination or as of the next payday, next regularly occurring payday for resignation. And in Massachusetts, it's the same, either immediately for involuntary termination or the next payday. So that's something to keep an eye on as well. This can actually be a pretty difficult situation for employers who have employees that work in various states. This has become a much more common situation since the time of COVID, because now you have a lot of employees who are working remotely, and so employers should remember that what matters is the state in which the employee is working. That is generally the state uh, whose laws apply for questions of the timing of final pay. Gary, if you could change to the next slide. Thank you. So another issue to consider, it's not enough to know that the final check must be provided. Or I say final check, I really mean the payment of final base wages. It's not enough to know when that check must be provided. It's also important to know exactly what wages need to be provided, what payment needs to be provided in that final check or along with base wages. And really the universal theme, the universal rule is that any payment, you need to provide any payment that is owing, that is identifiable and owing as of the final date of employment. And so that includes not only base wages, it also includes overtime pay, so payment for all hours worked in the final pay period. It can also include bonuses. Some employers have bonuses that are due not just at the end of the year, or that come owing not just at the end of the year, but bonuses that can be earned every pay period, as well as it just depends on the employee's system. And so it's important to take note, are there any bonuses that might be due? And secondly, and we'll get to this a bit more later on, are they mandatory or discretionary? And how are they calculated? And when are they calculated? An additional payment that might need to be made along with the final base wages is commissions. And oftentimes, in most cases, to determine commissions as well as when they're owed and whether they're owed, it's important to look at the commission payment plan. And finally, paid time off, depending on the state in which an employee lives. Paid time off might not be owed at all, or it might be mandatory. And so it's important to look at the state laws, as well as, to look at the state laws, and we'll get to that in a moment as well. Gary, could you change the slide? Okay, next, specifically looking at bonuses and commissions, to determine whether those are owed, as well as when they're owed, if they are owed. It's important to look at the plan documents, and the bonus. They're generally when regular bonuses are paid or regular commissions are paid, there is a bonus and commission plan that specifically identifies when or how those bonuses or commissions are earned, and when they accrue. And so employers should be looking at the plan documents to determine. There might be a situation where somebody has done the work, where an employee has done the work in order to obtain a bonus or commission um, prior to the final date of employment. But according to the plan documents, um, those bonuses or commissions are not actually earned until payment is received from the customer. And so that is something to that it's important to look at. Oftentimes it is important to look at with the help of an attorney. So again, when you're looking at bonuses or commissions, look specifically at whether those bonuses are mandatory or discretionary, and look specifically at what the plan language says about when they become due. And always remember, including when drafting the bonus or commission language, that any ambiguities favor the employee. So if there is a question about when a bonus or commission is earned, and whether it was earned prior to or after the final date of employment, if there is any ambiguity, that is going to generally be construed in the employee's favor. All right, please switch. Okay, thank you. And next, specifically, we're looking at paid time off, and that has really flourished as far as state law level paid time off laws. There is no federal requirement that when somebody's employment comes to an end, that they must be reimbursed for accrued and unused paid time off. So really it comes down to state law or to whatever the specific company's written policy is, or if there is not a written policy, what their actual practice is regarding whether paid time off is paid out or is just lost, whether there is a use it or lose it policy. And in most cases, state law governs. And so a number of states have laws that require that employees be paid out their paid, accrued, and unused paid time off as of the end of their employment. And those states include California, Colorado, Illinois, Indiana, Louisiana, Maine, Maryland, Massachusetts, Nebraska, North Dakota, Rhode Island, West Virginia, and Wyoming. Then you have a number of states that either don't have a specific law regarding whether paid time off must be paid out at the end of somebody's employment, or they have a law that says that the necessity of payout depends on the company's written policy. And so there you're looking at, I'm not going to list them all, but Florida is one such state. Florida is really the opposite of California. In California, there's a law for there's a state level law for pretty much every employee situation under the sun. And in Florida, I guess you could say Florida, the legislature defers to the federal government with respect to virtually any employment issue. And so Florida does not have a specific law regarding payout of PTO. And so in Florida, really it depends on the courts. The courts say that it depends on whether the company has a policy. If the company has a policy providing for payout of PTO, at the end of employment, then it must be paid out. And in that situation, it would be paid out with the final paycheck. Um, Other states like Alaska, Arizona, Arkansas, Delaware, Georgia uh, are similar in that company policy defines or determines whether there is payout of PTO. Um, and so it's just again, it's really important to remember that when somebody is about to be separated, when their employment is about to end, and you are considering whether to provide them with severance, it's important not to lose sight of that final paycheck and what exactly must be provided in that final paycheck. All right, if you could switch to the next slide. All right. And this just reaffirms, emphasizes the point I've been making. Final pay is wages that are required by law to be paid to the employee at the end of their employment. On the other hand, severance is a conditional benefit that's being provided to the employee in exchange for their agreement to do something um, for the employee's benefit, such as to waive potential claims that they might have. And so, under no circumstances should an employer try to condition the payment of final wages on an employee signing a release or a severance agreement. All right, next slide, please. And common execution mistakes in terms of the payment of final wages. Um, Oftentimes, commissions can be miscalculated. And that's a matter of um, looking at the specific commission plan, um, just to make sure what exactly is owed and that those commissions are calculated correctly. Um, another issue is delayed pay, where a deadline might be missed. For instance, um, an employer terminates an employee and doesn't pay them on their last day of employment, but instead just sends out the final check on the next regularly occurring pay period. If the employee is in a state like California, um, then you're looking at additional liability. And in many states, that additional liability comes with an obligation to pay um, attorney's fees for the violation of the wage payment laws. And so just when you're trying to resolve lingering risks um, that an employee poses, you are unintentionally creating new risks at that time. Uh, another issue is improper handling of payout of PTO. And finally, the matter of conditioning final wages on signing a severance agreement. And again, um, employers should always ensure that they don't do that. And it's always good to speak to an attorney when you're going through this process of determining exactly what is owed with an employee's final paycheck and when that is owed. And now I'll turn it back to Gary.
All right. Well, thank you. Before we take up questions, I just wanted to leave you all with some final takeaways. Strategically, not all terminations need severance. Of course, severance is a voluntary um, voluntary decision. We do think it benefits employers in a number of scenarios, but it's just a strategic decision, and it requires, especially when management is involved in both the decision to terminate an employee and then whether to offer severance, it can be difficult because sometimes those decision makers don't want to feel like they're conceding that they did something wrong, and that's not really the issue. It is again um, uh, risk avoidance. It's not anything more than that. Execution matters as much as decision. Colin's gone over some difficulties with that, and so um, the uh, now I'd like to open it up to questions. I've got one in the queue that I'll address, and then if anybody else has any, we'll happily address those. And while I address the questions, I do want to leave up our SHRM and HRCI credit activity. So there was one question that was the questioner said, my understanding was that it was where the employee lives rather than where the employee works. And I think that must have been based on when that question came up in the context of the timing of the final payment. And really it is where the employee works, not where they live. Now, I understand there can be sometimes some confusion. Sometimes an employer, let's say they'll have several offices across the country, and an employee, let's say, who lives in Rock Hill, South Carolina, which is very close to the border of North Carolina, they may live in Rock Hill, South Carolina, but they work out of the Charlotte office, which is only 20 miles up the road. And well, then it matters. So that employee lives in South Carolina, but where do they actually work? If they are working a remote office in South Carolina, they both live and work in South Carolina, even though they're tied to a North Carolina office, if that makes sense. But if they are routinely coming into the North Carolina office, they live in South Carolina, then they are working, actually working out of that North Carolina office. So it can get confusing, especially post-COVID, where we have many situations where there's work from anywhere, there's hybrid situations. So good question. Okay. In California, would it be permissible to suspend a non-exempt employee without pay until the next regular pay date and then terminate their employment on the pay date? Yeah, I would want to get into California law in this topic without taking a look into it. Okay, employee works where they live. I just addressed that one. Okay. Yeah. Is there a general rule? This is one question is there a general rule of thumb as to length of employee service when offering severance, such as 1 year of employment? Not really. I mean, that's an excellent question. It's like, my the goal kind of early on in the slides, I just want the severance amount to be enough when, inevitably that employee takes it to a plaintiff's attorney, that it is not such a paltry amount in context. And so the context is completely different if you have a 15-year employee who's getting terminated versus somebody who's worked there 6 months. If you're offering 2 weeks, to the latter, it's not a problem. But if it was 2 weeks to somebody who had been there 15 years, I may be more inclined to say up the ante, even though you're not required to offer more in any way. Okay. Okay. Is it necessary to have a severance policy in play? What are the pros and cons of having such a policy? No, there's really not um, you know, you shouldn't have anything widely disseminated by any stretch of the imagination. There may be some you may develop some kind of internal practice considerations, a consideration checklist for you to consider, and kind of hitting on the points that we've talked about is like you know, and then that would just be kind of considerations to take into account. But Since it's completely discretionary decision, I would not think that you would need to have a policy. It would be more like a checklist of, okay, these are the risks that exist with this potential employee. Are we satisfied? And good institutional knowledge of what you've done in the past. Um, you're not certainly bound to do what you did in the past, but you know, uh, precedence is always helpful. If you felt like that was a good decision 3 years ago when you let somebody go in a similar circumstance, it's probably a good decision now as well. Okay, let's see. Yeah, can you explain a little bit more about the personality side when severance makes sense? It's really just, I feel like this is an area where employers know more than their counsel. You know, you know your employees, and if um, you know, if you have an excellent defense, but the chance that somebody brings a claim is 70% higher with this particular employee than with your average employee, then it is kind of a case where the squeaky wheel may get the grease because it's like, if they're going to bring a claim, it could easily cost you thousands of dollars uh, to defend yourself, where it might be cheaper to offer a severance. So that if a person's particularly combative, particularly you know litigious, perhaps that should be taken into account. So that's one example. Uh, Okay, what are your thoughts on suspension versus paid or unpaid if you don't want to terminate immediately? Uh, I don't know if this is particularly the question, but I would say this. I have particular concerns about having an employee work after they've been presented an offer of severance. There are exceptions. There are times when that may make sense. And in fact, there are certain agreements you may have heard of called stay-on agreements, where you really want the employee to stay longer in a particular transition, maybe a new there's new ownership in your company, and you want to offer people a severance, but you want a certain core percentage to stay on. So you may offer a stay-on bonus for those people. But that's the exception. And the general rule is that you do not want the employee working beyond the date that you present them with the severance offer. And the reason is that um, a severance agreement, for everything that it can waive, can only waive things that occurred in the past. You cannot anticipate and have employees waive things that happen in the future. So if a person signs, if they're told that they're going to be a short-term employee, they're only going to work 2 more weeks, they sign it on that Tuesday that you present it to them. They work 2 more weeks. They could claim that they were discriminated against by their supervisor in the last 2 weeks, and the agreement would not cover that particular um, decision. So that's one of the reasons why it's important, we think, as a general rule, to not have the employee work beyond the date of presentation. Colin, do you want to take this next question about the PTO? I think you're on mute.
Yeah, I just got off mute. So we have taken the stance supported by policy that PTO does not accrue as of March 17, 2025, and move to an unlimited format. Save for the state of resident concern, are we generally good to take a no PTO payout stance? So let me read that one more time to fully understand it. That PTO does not accrue as of and move to an unlimited format. Okay. Um, so a situation like that, yeah, I would need to look at um, a state by state situation. I mean, in Florida, that would certainly be fine. There may be certain states that 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 might not allow for the situation that uh, you've contemplated, where there is simply no accrual of PTO and therefore no payout as of somebody's separation of employment. Um, so just off the top of my head at this time, I can't say for certain that that would be valid in every state. It sounds like a good idea to me, at the same time. And um, uh, you know, there is a possibility that that would be fine in every state, but just uh, I would need to look at individual state laws to make a final um, determination on that. So certainly, if you have a question about a specific state, and you'd like to contact Gary or me after this presentation, please feel free.
Yeah. Let's see. There's another question about, is there an EEOC or other federal agency rule about the amount of severance for consideration purposes since severance package becomes a contract when executed? No, there's not any rule about that. Uh, of course, once you commit to a certain amount, um, and you've offered it and it's been accepted, you're on the hook to pay that. But there's no guidance or requirement that a certain amount, if being offered at all, or needs to be offered. That, um, Let me take a moment to read this next question. Um, yeah, at the timing, this kind of gets a little bit into the question here is, if an employee has been underperforming and the manager requests to put the employee on a 60 or 90-day performance improvement plan, but has low confidence the employee will meet the minimum requirements for the PIP. When the PIP is presented to the employee and they also feel that they will not be able to meet the requirements for the PIP, is it prudent to offer a separation package at that time as an option? Well, the problem, I mean, again, this is one of those cases where nuance matters, but generally speaking, it's generally best to make the decision whether that day when they're presented the severance will be their last day with the company, or the last day that they're required to work for the company. You don't want to have a situation where, generally speaking, where they're thinking about whether to accept the severance and then going back to work and working on, uh, the regular work matters. You would basically want them to be thinking about it and having all their work responsibilities in the past. That's generally the structure that works best.
Another thing I would add is just that when you should be careful when you start thinking about treating one employee differently than how you've treated other employees. The best rule of thumb is to just be consistent um, from one employee to the next. You know, if you're in a situation where based on the employee's performance, you would normally subject them to a PIP, then you should subject them to a PIP. The moment you start deviating for individual employees is when employees start saying, "Hey, I'm being treated differently, and how am I different from this person, from these other people?" Um, and so I would be very careful about a situation like that where you are kind of anticipating that they're not going to be able to comply with a PIP, and you're doing something different for them that you haven't done for other employees in the past. Especially where, as Gary said, they could turn down the severance agreement and then be still working there and disgruntled.
Okay, there's another question. Do you have advice on the best way to offer resignation in lieu of termination to limit liability? Again, this is going to be very case and fact specific, but definitely there are times where um, you may want to offer resignation in lieu of termination um, as an option to the employee, um, especially in a case where they want to be able to tell prospective employers or maybe their former coworkers that they resigned and to be truthful about it. And um, so, yeah, I mean, we have to just talk through the specifics of that, but there's definitely a way to do that. Um, but um, you just have to understand the limitations of that. In most cases, when you do this, for example, that's not going to be deemed a true resignation for purposes of unemployment. For example, if in many states, including Florida, if an employee resigns, um, they're not entitled to unemployment benefits. But if they resign in lieu of termination, they will more than likely be entitled to unemployment benefits. So that's definitely something to keep in mind. Okay. Okay. All right. Well, I think we're going to wrap it up from there. If we don't really have time to go through the remaining questions, but we'll be uh, happy to talk to anybody that wants to reach out to us. We have our contact information available to you, and we enjoyed it. And thank you all for joining us here today.
Thank you.